Here we are in the video lecture for Chapter 9, Legal Problems in Reporting Courts. The legal system is important in contemporary society. It's the place where the power of government with respect to individual liberties comes into play. Now, if you haven't been a defendant in a criminal case or even a participant in a civil suit, the justice system may be kind of murky to you. One of the things you need to understand, though, is that the role of the media with respect to the justice system is one in which we report on what happens because it's necessary for society. In fact, the tradition of openness in criminal proceedings goes back almost 1,000 years. And it's important because openness provides people with the knowledge of how their government operates and gives them first-hand knowledge that justice is being done. And a quote from Chief Justice Warren Burger to the effect that, yes, we can ask that the courts do their jobs. We don't demand that they be perfect, but it's hard for us to accept that they're doing their jobs if we can't see what's happening. Lately, though, there has been a dangerous trend. Some courts have decided that national security or the protection of the investigatory process or the interests of the defendant allow them to take cases through the judicial system completely secret. And it's dangerous because, as one judge once said it, democracies die behind closed doors. The secret proceedings contribute to a loss of respect for government and trust in its institutions. With respect to criminal cases, no one knows who's been arrested and put on trial and what the charges are. Evidence is concealed and witnesses are not known. Convictions are kept from the public. And then the American criminal justice system develops its own population of the disappeared. Please see the footnote below. Public trials, on the other hand, allow people to see who the government chooses to prosecute, the method the government uses to investigate cases, the witnesses governments bring in trials, and the testing, the scientific standards that's used to judge and help convict or find innocent the defendant. See, public evidence is a check on the introduction of falsified materials. That's one of the keynotes to having public criminal trials. People who know about the case, but who are not present in the courtroom, can read or see or hear what's being said as testimony. And if they happen to have independent knowledge of the facts, and that independent knowledge does not square with the testimony being given, they can come forward and tell the prosecutor, tell the defense, tell the judge that perjury is taking place or that the truth has been altered to ensure that the Sixth Amendment rights of the defendant are preserved. When civil cases are secret, we create a second type of justice for people who have money and power. You'll see a reference to the Sharon Stone civil suit. Her celebrity and her lawyer's power kept the dispute from public view. In fact, you'll read that it was only by accident that the suit was discovered. Courts in Connecticut had a secret system that allowed parties in divorce cases to pick from a range of secrecy with complete invisibility at the top end. And it was discovered by accident by a reporter who was working on a divorce story. If you know that the courts will give you secret justice that no one knows about, then you know that the justice system has failed. People with money can avoid embarrassment. People with power can choose to keep their indiscretions locked away. And that's a problem with having a system of justice which is not completely open. National security has played a big role. You should know that after the attacks of 9/11, the United States government took thousands of persons, mostly immigrants from the Middle East, into custody. These detainees, as a general rule, were not allowed to contact family or loved ones, where they were not permitted to get lawyers. Those who had lawyers already, their lawyers couldn't find out where they were being held. In some cases, there was some limited representation. News media, hearing what was going on, especially getting calls from family members saying, hey, my husband, my son, my brother-in-law has been detained, began to look into this. They wanted to know what the government was doing. Well, the government refused to provide the information. The government said, we can't tell you anything about any of the people that we've detained because of national security reasons. And they relied upon what was known as the Watson Declaration. A declaration is a statement made by somebody that the courts then factor into their decisions as to what they're going to do. And the Watson Declaration was made by the counterterrorism chief for the FBI, Dale Watson, who said that the government could not release information because any information that was disclosed could help terrorist groups. And in arguing against allowing the media to know about the detainees and the court proceedings against them, the government cited something called mosaic. Now, it was explained this way. The government said foreign intelligence is kind of like a mosaic, kind of like a jigsaw puzzle. Thousands of pieces come together. And the government said, if we provide any information about anybody who was detained, that may give the terrorists information that a sleeper agent has been detained so that they can change their plans. By keeping the identities of everybody who's been detained secret, the terrorists cannot make changes in their plans to be able to carry out another terror attack against the United States. I have, when I've spoken publicly about this, said the fact that they can't get in touch with these guys, the fact that their families are talking about how their loved one has been taken away by the government should give an indication that a sleeper agent may have been detained. But the government says a single piece of information may have great significance depending upon what the terrorists know in addition. And what may seem trivial to the uninformed may appear to be of great moment to one who has a broad view of the scene and may put the questioned item of information into its proper context. So we had a couple of cases with different outcomes regarding detainees. The North Jersey Media Group, a group of media entities, sued for access to deportation proceedings involving detainees, saying that the Sixth Amendment required public proceedings. The district court agreed, the case was appealed, and the Third Circuit Court of Appeals held 2-1 that the court should defer to the federal government's judgment about what, if any, information could be public. And if the federal government said national security requires it be secret, that the court should simply accept the federal government's word and do what it says. But in Detroit Free Press versus Ashcroft, the Detroit newspaper sued for access. It won in the district court. The case was appealed by the government to the Sixth Circuit Court of Appeals, and the Sixth Circuit upheld the district court. In the Sixth Circuit, the government once again invoked mosaic, but the panel rejected that argument, saying, guarding military and diplomatic secrets at the expense of informed representative government provides no real security for the republic. Both cases were appealed to the Supreme Court, and the Supreme Court turned both of them down, because the Supreme Court would then have to rule that either there would be access or there would not be access. What that means practically is that in the Sixth Circuit you can seek access and you should get it, and in the Third Circuit you wouldn't be given access. And the government could afford a lot of instances of providing access by simply moving the cases from the Sixth Circuit to the Third Circuit, because each circuit is independent and the holdings in each circuit apply only to that circuit. Well, let's move on to more mundane matters, access to civil and criminal matters. And we begin with Gannett versus De Pasquale. This case begins with a pretrial hearing to determine the admissibility of evidence in a killing. And just so you know, here are rules about evidence. Judges have the responsibility for protecting the process of justice in both criminal and civil cases. And one of the primary areas where judges have responsibility is deciding what evidence can come in and what evidence will be excluded. Remember that the jury is supposed to judge the case on the basis of the evidence alone. So if you allow in evidence that's not reliable or trustworthy, or evidence that's gained through a violation of constitutional rights through an illegal search and seizure, that would allow the trial to be decided on bad evidence. So the judge has to consider challenges to evidence that one side is proposing to produce in court. In the Gannett case, the government was going to offer a statement made by one of the defendants and physical evidence in the form of a pistol that was believed to have been used in a killing. So these challenges are brought before the actual trial so that everything is decided before the evidence stand up in front of a jury. And the reason we do that is because if the challenges to evidence were made only during trial, the trials would take longer. The judge would have to sit and think about whether the evidence should come in or be excluded, and judges do not like to be put on the spot because they are more likely to make a mistake if they have to make a snap judgment. So that's one reason why we don't do that during the trial. A lawyer who had built his or her case upon that one piece of evidence that then gets excluded at trial would then have to work up a new argument with different evidence. That means the trial would have to be stopped. The jury sent home, and everybody have to wait until the lawyer could come up with a new theory of the case. Problems with this is that these challenges take place in a courtroom, and we in the media report on them. That can create problems in that sometimes evidence which is excluded in the pretrial hearing winds up being reported on in the newspaper, newscast, or online. Prospective jurors who see this information about the, quote, evidence might then be influenced by something that cannot legally be considered in deciding the case. And that's one of the reasons why judges sometimes try to close such hearings so as not to influence prospective jurors. But back to Gannett. So, a pretrial hearing to determine the admissibility of statements made by one of two men who are believed to have committed a murder. The judge, Daniel De Pasquale, that's the De Pasquale and Gannett versus De Pasquale, closed the pretrial hearing to protect the defendant's right to a fair trial. If the testimony were excluded, the statement made by one of the two men, then the jury might remember that when they came in to judge the case. A local newspaper owned by the Gannett Corporation sued over the closure. We want access in media to the pretrial proceedings because most criminal cases never go to trial. You see, if a judge decides that a particularly harmful piece of evidence is admissible, then a defendant will make a deal with prosecutors. And conversely, if a piece of evidence is found not to be admissible, the prosecutors will try to make the best deal possible with the defendant in a plea bargain, or the case will be dropped entirely. So we want access because it provides a look at the conduct of the police. As James Goodell, a former vice president of the New York Times, once said, a successful suppression motion will probably mean that an account of the improper methods police used to extract a confession will be brought out only at the pretrial hearing. And this is information that the public needs to have if its public officers are to be held accountable. So, pretrial hearings and suppression motions are a way to prevent wrongfully obtained evidence from coming into a trial, but as importantly, they are also a picture of the methods that the police and the prosecutors are using. And if nobody gets to see that, then yes, a defendant may have a case dropped, but the pattern and practice of conduct is still going on because nobody knows about it. Now, the Intermediate New York Appellate Court reversed the judge, ordered that a transcript of the pretrial hearing be made public. The highest appellate court in New York reversed and sustained the closure. The case was appealed to the Supreme Court, and the Supreme Court held by a 5-4 margin that the pretrial could be closed. Justice Potter Stewart wrote the opinion for the court, saying that the term public trial did not give the public a right to attend trials, but instead, the Sixth Amendment meant that the defendant could exercise a personal right to make his or her trial public. Chief Justice Warren Burger wrote a concurrence. He was part of the 5 that said that trials should be public, but that a pretrial hearing was private to the parties and should be closed. Now, Gannett versus De Pasquale is a particularly troublesome case for us because it stands for the proposition that part of the justice process, the thing where the government has the most intimate contact with a member of the public, part of that can be closed. We're going to see, however, that subsequent cases have supplanted Gannett and have made pretty clear that the whole of the justice process should be open to the public and the press. The dissenters in Gannett said that public interest required openness in both pretrials and trials. But for the year in which Gannett was the biggest case in coverage of trials, there were a lot of things happening. About 400 attempts to close pretrials and trials following the Gannett case. But then we had Richmond newspapers versus Virginia. This is a year after Gannett, and the Supreme Court holds in Richmond newspapers that trials are public and open according to the Constitution. In Richmond newspapers, a defendant asked that his trial be closed to the public. Actually, it was the defendant's lawyer. The trial judge agreed and closed that portion of the trial to the public. The reporter for the Richmond newspaper didn't object at the time, but the next day went back and objected to the closure and asked the judge to release a transcript of what went on. The judge refused, and the case ultimately gets to the Supreme Court. The Supreme Court then is faced with the question, can a trial be closed for reasons other than protecting the defendant's right to a fair trial? Chief Justice Berger wrote the opinion for the court. He talked about the history of openness in Anglo-American law. He cited commentary about the effect of having public testimony on the proceedings and concluded that there was a therapeutic value for the community in public trials. And the reasoning goes like this. Something happens to you or a member of your family or someone you're close to. There's an arrest, but then no one knows what happens after that. And for all you know, the person who committed the crime may have been let go scot-free, might have moved on to another part of the country. The fact that we have public trials means that you can go there, or the media can go there and report on it, and you can know what happened to the person who did the terrible thing. It gives people an idea that the justice system is worthwhile and it functions properly. Berger also spoke about openness in society. And we have this famous quote, people in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. And we know this because each and every one of us has been in a situation in which a judgment has been made that affects us or someone we know, and we don't know what happened when that judgment was made, and we are suspicious that the judgment may have been improperly made. Well, if the process was open, we'd still gripe, but we wouldn't worry about the institution. We would worry about the individual. Berger also said that the press stand in for the public. It's part of our watchdog function because he acknowledged that people can't get down to trials because we're awfully busy. So the press goes there. It'll oftentimes get preferred seating or access because the press is there to report to the larger public about what happens in the courtroom that people present can observe. After Richmond newspapers and Gannett, reporters started carrying what were known as Gannett cards with a written objection to pretrial or trial proceedings. There is a copy on page 673 of your textbook. It's an important thing to know. You might want to copy it down if you're going to be doing any work in media. It's an important thing at the time that a pretrial or trial is being closed that you make an objection in order to preserve access rights. It's a little more difficult if you have simply left the courtroom and only the next day or a week later decided that you should have had access rights. In fact, I covered a pretrial hearing in the case of an assassination of a federal judge In fact, it was the first assassination of a federal judge in probably about 100 years. The contract killer was Charles the Hitman Harrelson, who is the father of Woody Harrelson, the actor. And in that case, when confidential informants were going to be brought to court to testify in a pretrial hearing in the assassination case, Judge William Sessions would order the public to leave the courtroom so that the identity and the testimony of the confidential informant could be protected from disclosure. And it was the first time I had the opportunity to stand up in court, not as a lawyer, and say to the judge, "Your Honor, I object to the closure of this portion of the hearing." I said to him, "This is the murder of a fellow judge, one of your co-workers, one of your friends, and people have questioned whether or not you should be sitting in judgment of this case because of your connection to the judge. Closing the pretrial, closing any portion of the proceeding, can only lend credence to those who suggest that fairness may not be accomplished." And the judge was very nice. He looked at me and said, "Thank you very much. Now get out of my courtroom." And I left. You still need to do that, if for another reason than to remind judges that, yes, there are people who have an interest, the press, who relate to the public, the people who are affected by the law. Following Richmond and Gannett, the courts have over the years come up with a test for closure. It has 3 parts, just as most of our other tests do. And so before a judge can close a pretrial hearing, the judge must, number 1, conclude in a hearing, that is, in a formal court proceeding, that without closure there would be irreparable damages to the defendant's fair trial rights. Number 2, the judge has to conclude in the hearing that there were no alternative means to deal with the threat to the defendant's fair trial rights. And number 3, must conclude that the closure would be effective. All 3 of these things must be concluded in a hearing open to the public. Before a judge can close a trial, we start the case and wind up with a conviction or a not guilty verdict, the judge must, in a hearing as well, number 1, make detailed findings of what it considered and concluded. Number 2, conclude that there was a substantial probability of prejudice. Now, substantial probability of prejudice is a term of art, but you need to know that, because if it doesn't rise to that level, the case cannot be closed. And the substantial probability of prejudice should be to a compelling interest of the defendant, government, or a third party, and the closure would prevent the prejudice. And third, the judge must have considered alternatives to closing the trial and then choose the least restrictive means to protect the compelling interests. Now, what this means is the judge cannot simply say, "I think the defendant might not be able to get a fair trial, so I'm closing the trial." The judge has to work through in detail how the defendant's rights or how the rights of the government or a third party would be jeopardized by having a public trial. It's a pretty high standard to meet. Let's look at some of the cases following Gannett and Richmond. In Globe newspaper versus Superior Court, there was a state statute in Massachusetts that made certain trials of certain sexual offenses involving victims younger than 18 closed to the public. And you can see the rationale for the statute. If you have a minor who's been who's the victim of a sexual offense, you don't want to re-injure that minor in a public trial. But in the Globe newspaper case, the Supreme Court said the exclusion of the public violated a First Amendment right of access to criminal trials. Now, what they didn't say was that all trials like this had to be open. But what Justice Brennan was saying is that you cannot simply have a blanket exclusion, and that a court would need to consider on a case-by-case basis whether the closure would be needed to provide for the welfare of the victim, which means going back through that hearing in which the judge has to conclude that there would be a substantial probability of prejudice to the interest of the victim, who would be the third party. Press Enterprise versus Superior Court, also known as Press Enterprise 1. A judge in California, down in Riverside County, decided to exclude the public, including reporters, from the jury selection process in a rape case. The Supreme Court unanimously held that the closure was not constitutional, that there was a public interest, that there was a First Amendment right, that the Sixth Amendment right applies to the public being able to see what happens in court in both the trial and the pretrial. So you can see that this backs away from Gannett. In Waller versus Georgia, a judge closes a pretrial suppression hearing. The Supreme Court holds that the closure was not constitutional. Now you need to remember, though, that if the judge had conducted the three-part test, and the Supreme Court found that the judge correctly concluded after the three-part test that the hearing should be closed, it constitutionally would be closed. Press Enterprise 2. Again, the Press Enterprise in Riverside County. The newspaper challenged the closure of a probable cause hearing. We'll go through what probable cause hearings are a little later on. The Supreme Court held that the judge's conclusion that there was a reasonable likelihood of substantial prejudice was not sufficient. Instead, the court said the judge would have had to conclude that there was a substantial probability of prejudice before closing the pretrial hearing. So reasonable likelihood is not the same thing as substantial probability. And the law is remarkably precise sometimes, although it's sometimes awfully vague. So, free press versus fair trial. We need to understand that we in the media can influence the outcomes of trials through inflammatory reporting, speculation, or outright efforts to persuade a jury to convict a person. Those things we've done as media professionals, and those things have harmed the justice system. And here we're going to talk about instances in which we have just been terrible, how we have led to injustices. Because remember, the jury has to decide a case on the basis of evidence produced from the witness box. And the jury cannot constitutionally be influenced from the outside. And in the cases that are coming up, we'll see how media entities robbed defendants of their right to a fair trial under the Sixth Amendment. But before we do that, we have to understand how the system works. Now, I'm assuming that most of you have not been arrested, prosecuted, and convicted of either a major crime or a minor one. So for your benefit, this is what happens. A crime is committed, the crime is discovered, the police are notified of the crime, or in some cases they witness the crime taking place. A suspect is arrested. Now, when police arrest a suspect, it is to the goal of the police. The goal of the police is to clear cases. And clearing a case means that the police conclude that a particular person is responsible for committing a particular crime. So a person is arrested on suspicion of burglary. The police may conclude that the burglary suspect is in fact the person who burgled 100 homes in the city. Having made that conclusion and assigning responsibility to the one burglary suspect, the department has now cleared 101 burglaries. Clearance doesn't mean convicted. Clearance doesn't even mean the case is good enough to take to trial. It just means that there are no unsolved cases, no cases that are open. No one's been punished, no one's been held accountable, but the police consider that someone has been identified as the perpetrator. Now, once a person has been arrested, a defendant can plead guilty. Oftentimes, this is because they have no money to pay for a defense attorney, and the idea of the Public Defender's Office is a great one, but the Public Defender's Office has been underfunded. And often the attorneys in the Public Defender's Office have too many cases to be able to handle everyone well. And if the defendant has no money, the defendant sits in jail. If you can't make bail, you stay in jail. Now, bail, you may have heard the radio ads or seen the television ads about, we'll get you out of jail if you've been arrested. Well, bail is where you put something of value up as a guarantee that you will show up for the proceedings. Bail is used only for the purpose of guaranteeing the appearance of the defendant. Bail is not meant to be a punishment. In fact, if you try to use bail to punish a defendant, that is not constitutional. The amount of bail has to be reasonable, and the amount of bail is set based upon a number of factors, including the seriousness of the crime and the risk that the defendant will flee once out of jail. A defendant who doesn't have the money or resources to make bail or to have a bail bondsman make a loan to make bail often plead guilty rather than sit in jail for months awaiting trial, which can result in a term in jail for months. Bail bondsmen are taking a risk. They are, in essence, loaning you the money to get out of jail. So if you're arrested, you're arraigned, and the judge sets bail at $100,000, you have to put up $100,000 in cash or $100,000 worth of property that's valued at that much. And very few of us have that. So instead, we will go to a bail bondsman. The bail bondsman will say, okay, I will loan you the $100,000. You have to pay me 20%, which means you may be paying $20,000. The bail bondsman then notifies the jail that they will put up your bail. They are the guarantors of your appearance. If you don't show up, the bail bondsman loses the $100,000. And then the bail bondsman doesn't like you much. What the bail bondsman will do in order to avoid losing the $100,000 is to check and make sure that you're going to show up. And if it looks like you're not going to show up, then they will get people to find you and take you to the court proceeding or take you to jail. And we've had some reality shows about people who hunt for bail skippers. But back to the lecture. All right, the suspect is arraigned. In arraignment, the judge reads the charge to the defendant, asks the defendant about representation. The defendant is allowed to enter a plea, guilty or not guilty. Now, throughout this process, bargaining takes place. The bargaining is between the prosecutor and the defendant. That is through the defendant's lawyer. The prosecutor can do a couple of things. The prosecutor can offer to let the defendant plead guilty to a lesser offense, a less serious offense within the category for which they've been arrested. The prosecutor can allow the defendant to plead guilty in return for a recommendation of a lesser punishment, or the prosecutor can bargain with the defendant to plead guilty in return for having the prosecutor drop other charges. In our hypothetical case, the burglar who had been caught burglaring one home and is suspected of 100 more, the prosecutor may offer to let the defendant plead guilty to one count of burglary in return for having the other 100 burglary charges being dropped. It happens. It may seem tawdry and not particularly just, but it happens because the court system cannot handle all of the people who get arrested. After the arraignment, we have two ways to get to trial. One is indictment, the other is a probable cause hearing. Indictments are returned by grand juries. Now, grand juries are distinct from petit juries. Grand juries, generally speaking, deal only with whether there is good reason to send a defendant to court to face trial, or whether there's not enough evidence to send a defendant to court. Petit juries, on the other hand, are the juries that sit in judgment of the defendant in a trial. The grand jury was created to stand as a check on overzealous prosecutors. It would give ordinary citizens the power to decide if the prosecutor's case was sufficient to justify putting the person on trial. It was created in England, and it evolved to provide those protections against overzealous prosecution in the late 18th century. In the United States, the Fifth Amendment carries the protections. The relevant portion says no person shall be held to answer for capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, with some exceptions for times of war or public danger. So, traditionally we think of juries as being 12 people who will sit in judgment in a trial. The grand jury ranges in size from 12 people up to 23 people. We have criminal grand juries and we have civil grand juries. Civil grand juries exist as investigatory bodies to look into the conduct of government. They're not involved with indicting people. They're just involved in making reports and suggesting that we should fix a problem or two. Criminal grand juries are those that decide whether to indict or not indict a defendant based upon evidence presented by a prosecutor. In reality, grand juries generally are tools of prosecutors. The prosecutor decides which cases to present to the grand jury. The prosecutor is the only lawyer allowed to speak or question witnesses, and the prosecutor decides which evidence and witnesses will be presented to the grand jury. So, this process allows prosecutors to steer the grand jury to issuing an indictment against defendants, but it also allows prosecutors to avoid taking much of the heat when they don't want to prosecute. Instead, in the grand jury process, they give the grand jury selected evidence, and then when the grand jury decides not to indict, the prosecutor says, hey, I took it to the grand jury decided to no-bill a defendant. You may remember that in Ferguson, that the prosecutor took the case against the police officer in the Michael Brown killing to the grand jury and put witnesses in front of the grand jury, questioned very strongly those witnesses who suggested that the killing might not be justified, and then simply accepted the testimony from those witnesses who talked about how Michael Brown was a threat. The result was the grand jury no-billed the police officer, and the DA said, well, hey, you know, I gave it to the grand jury, they decided not to indict him, and what can I do? Don't blame me. So, if the grand jury decides to no-bill a defendant, the case goes away because the defendant is cut loose, there's not going to be a trial. If there's a true bill returned, then that means the grand jury has indicted the defendant. They've concluded it's more likely than not that the defendant did a bad thing and should be put on trial. Here we have more bargaining. Now, if the defendant is not billed, or the grand jury does not return an indictment, then there's nothing to bargain over. But if the grand jury comes back and indicts somebody, then the prosecutor has a little more power, and the defense attorney is going to be more concerned about what's going to happen to the client. If the prosecutor does not want to go to a grand jury, there's an alternative way to get to trial called a probable cause hearing. The probable cause hearing takes place in front of a judge. In the hearing, the prosecutor presents witnesses and evidence and argues to the judge that probable cause exists, that it's sufficient to have the court bind the defendant over for trial. In a probable cause hearing, the defense lawyer is permitted to question the witnesses and object to evidence and present some rebuttal. The defense does not present its case at the probable cause hearing for obvious reasons. All right, what are the obvious reasons? If the defense puts forward a defense for the defendant, the prosecutor will know what the defense attorney is going to try to prove in court, which allows the prosecutor to assign investigators or tell the police department about the defense strategy. And then the police can go and try to poke holes in the defense's case, and makes it more difficult for the defense to prevail. At the end of the hearing, the judge will make a finding that there is or is not sufficient reason to bind the defendant over for trial. Oh, one other thing about grand juries. The defense lawyer does not get to say anything in the grand jury. So the defense lawyer can go to the grand jury, especially if his or her client is being questioned by the prosecutor. The prosecutor gets to ask all the questions. The defense lawyer can't object, cannot provide rebuttal. So the probable cause hearing is the instance in which the defense lawyer gets to try to influence whether or not his or her client goes to trial. After the indictment or the finding of probable cause, we have limited discovery. Remember, we talked about discovery at the beginning of class. We get to discover what information and evidence the other side has before we go to trial. The defense is entitled to police reports, a copy of what the defendant said to the police, including audio recordings or video recordings, the names of expert witness, and the results of scientific testing. The prosecutor also is under the obligation to provide the defense with exculpatory evidence that the government has. This is called Brady material because it comes from a case, Brady versus Maryland, in which the Supreme Court said it is a violation of constitutional rights for the prosecutor to conceal or withhold evidence that would tend to show that the defendant did not commit the crime if the prosecutor keeps that away from the defense. So, under a Brady motion, the prosecutor is required to disclose any evidence favorable to the accused, anything that would show the defendant is less likely to have been guilty, anything that might reduce the defendant's potential sentence, or evidence going to the credibility of a witness. And if you've paid attention to news stories for however many years, you'll know that every so often a case will come out before the public in which a key prosecution witness was in fact not as reliable as the court found. And we have convictions where someone was sent to prison on the basis of the false manufactured testimony of a witness who may have been facing prosecution from the prosecutor and then made a deal to provide good testimony for the prosecutor against the defendant. And the relationship between the prosecutor and the prosecutor's witness is never produced. And that's kind of tough, because if you're sitting in a jury and a witness comes up and says, I saw John Doe stabbing the victim, you may be inclined to believe that. But if the defense is then able to ask the witness if the witness has made a deal with the prosecutor, then you are less likely to believe that testimony, because, as the defense lawyer will say, the prosecution has paid for this false testimony, and the witness has a vested interest in seeing to it that the defendant is convicted. Now, once discovery takes place, then we can have motions to suppress. The defense will take a look at the police report, names of witnesses, results of scientific tests, and then it may say, we don't think this evidence ought to come in because the evidence is unreliable, because the evidence is not conclusive. And at suppression hearings, a lot of them are on statements or confessions by the defendant, physical evidence, and the results of scientific tests. At the hearing, the defense will try to show the judge the reasons that the evidence cannot be used in trial, and those reasons include unlawful search and seizure of the evidence, the unreliability of a witness, or the lack of legitimate scientific validity of tests. If the evidence is suppressed or allowed to be used, plea bargaining takes place again. If the prosecutor loses the ability to use certain evidence, the prosecutor may doubt the chances of conviction and then will offer a better deal rather than risk losing a case. If the defense loses, the defendant may offer to plead guilty in return for some benefit, knowing that a conviction is more likely. Now, we've talked about bargaining all through the lecture up to this point, and you should know that because of all this bargaining, between 94 and 97% of all criminal cases never go to trial. From 3 to 6% of all criminal cases go to trial. So 6 out of 100 times a case will go in front of a court. The few cases that do go to trial usually are those that are sensational enough that the prosecutor won't risk public anger in the next election. Also, the prosecutor may believe that an example must be made of the defendant, or the prosecutor wants to demonstrate to voters how tough on crime he or she is, or, it happens every once in a great while, the defendant wants to go to a public trial. And usually these defendants are really big headaches to defense lawyers. The public pretrial hearing. The hearings are public for the reason that the people ought to know if police are coercing confessions or violating the Fourth Amendment rights of people not to be subjected to unreasonable search and seizure, or trying to bring in unreliable testimony. You need to know if you can trust the cops. You need to know if you can trust the prosecutor. You need to know how the justice system works. But both prosecutor and defense lawyers may not want the hearings to be public because they are concerned about the impact on the actual criminal trial or the loss of public confidence in the justice system. A lawyer may not want a pretrial hearing to be open because that hearing may expose evidence that is bad for the defendant. Or if the defense lawyer knows that they're going to go to trial no matter what, the defense lawyer may want a pretrial hearing closed because evidence that will be excluded as a result of the pretrial hearing will now be out in front of the public. And that might prejudice them because even if they don't hear that evidence in the trial, they will remember reading about or listening to stories about that evidence. The prosecutor doesn't want them opened in some cases because it reveals that the cops are doing bad things. The prosecutor may not want a pretrial to be open because if the prosecutor loses that, that's public evidence that the prosecutor hasn't done a great job. And remember, prosecutors are elected, and you get reelected by being tough on crime and being very effective. So, talking about pretrial hearings, we're back to Gannett versus De Pasquale. Now, at trial, if trials have a fatal error, the trial must be ended and the case tried again. When a trial has a fatal mistake, it results in a mistrial. And in the law, there are about 1,000 different reasons for declaring a mistrial. Recently, social media has become a reason for mistrials. Jurors may be tweeting about the proceedings while they are sitting in the courtroom. They may reveal biases or some other reason not to trust their judgment. That leads to mistrials. Jurors who are consuming social media can read comments from people outside the trial, and when those people have opinions or who refer to evidence that hasn't been presented in the case, the juror may be influenced, and the case leads to a mistrial. In some instances, jurors are starting to do their own research. So there's an example that in a case involving a traffic accident and testimony about the intersection where the accident occurred, some juror will Google and go to Google Maps or go to the Google Earth and look at the map of the intersection, may look at pictures of the intersection, and based upon the juror's examination of that evidence, may come to a conclusion that it's not proper, because the only evidence the juror is supposed to consider is the evidence presented in court. So the juror is not supposed to go out and do his or her own investigation. That's a bad thing. Our impact on law and the mistrials: if a juror forms an opinion as to the guilt or innocence of a defendant based upon stories in the media, well, that can lead to a mistrial or later a successful appeal of a conviction. Publicity during the pretrial phase or publicity during the trial can and have had impacts on cases. Now, judges are responsible for preserving the Sixth Amendment rights to a fair trial for the defendants, and if they don't do their jobs, the cases can be overturned. And in fact, judges can be singled out for criticism for not protecting the defendant's rights. Let's look at some cases involving pretrial publicity. Irvin versus Dowd. This case in 1961 was the first time the Supreme Court overturned a conviction because of pretrial publicity. The court held that the jury had been tainted by exposure to stories in local media, and that the exposure to those stories denied Leslie Irvin an impartial jury. And what happened was, Irvin had been arrested on burglary and bad check charges. While he was in custody, he was accused of 6 murders. The prosecutor held a press conference and announced that Irvin had confessed to all 6 murders. The judge tried to deal with that publicity. He moved the case to the adjacent county on a defense motion, but the adjacent county is adjacent, so that when prospective jurors were questioned in the voir dire process, 90% of them expressed an opinion about Irvin's guilt. Irvin was convicted and sentenced to death. Eventually, the Supreme Court heard Irvin's appeal and voted 9-0 to overturn his conviction. Justice Tom Clark wrote about the avalanche of stories that referred to Irvin, the murders, the confession, and even Irvin's nickname, Mad Dog Irvin, in the months before the trial. It was the newspapers, radio stations, and TV stations. They blanketed the area with stories about Irvin. This, of course, is pre-internet days. Now, Justice Clark did note that just because there was a lot of information out there, that alone was not sufficient to reverse the conviction. And Justice Clark wrote that the trial would have been proper if it had been shown that all of the jurors were able to set aside their opinions and judge the case solely on the evidence presented. But in the case, the transcript showed that the jurors, the people on the prospective jury pool, and people who ultimately were seated on the juror, had some pretty set opinions as to Irvin's guilt or innocence. Rideau versus Louisiana. Wilbur Rideau was arrested and charged with robbery, kidnapping, and murder in connection with a bank robbery in Louisiana. A television crew came down and filmed Rideau's interview/interrogation by the sheriff. In the interview, Rideau admitted to the robbery, kidnapping, and murder. Rideau did not have a lawyer present for the interview. The Supreme Court reverses the conviction because of the prejudicial pretrial publicity. 3 of the jurors had watched the interview on television, and also 2 members of the jury were deputies. The defense lawyer tried to have them stricken from the jury, but the defense lawyer had used up all of his challenges, and so they were seated. Now, these guys were guilty. They were retried, found guilty again. So the question comes up in class sometimes is, why reverse the convictions? Why let them have a new trial? Why put everybody through that again? And I tell students that constitutional rights exist for everybody, guilty or innocent. There is no way to know in advance whose rights need to be protected, so everyone's rights need to be protected. You know, it's kind of like this. Who's going to decide whose rights need to be protected? You're going to have some person who has perfect knowledge, who's going to be able to predict guilt or not guilt. If we had someone like that, we wouldn't need any justice system. And we have had any number of persons who've been executed who did not commit the crimes for which they were put to death. This has come up a lot lately as a result of DNA testing. People on death row who've been on death row for 30 years, now exonerated because DNA showed that they were not the rapist or the murderer. Tests, scientific tests used in court which are not reliable. We have recently a case in Texas in which a man was accused of committing murder through arson of his 3 little girls. The prosecution brought in testimony for a supposed arson expert, and the arson expert testified as to burn patterns and how it showed that the fire in the house that killed the 3 little girls had to be the result of arson. Well, that testimony was challenged by real arson experts who said, no, that burn pattern does not show that it was arson. And in fact, the defense and the arson expert said it's likely that the fire was purely accidental, that it broke out on its own. But the man who'd been convicted of arson and 3 counts of murder was put to death. So we need to have a good examination of what happens in the justice system, because it is a life or death matter. I mean, what if it were you or a loved one being prosecuted? Wouldn't you want public examination of the witnesses and the evidence to be sure that both were reliable? Here we are with Murph the Surf. Murph the Surf is a key Supreme Court case regarding pretrial publicity. Murphy versus Florida. Murphy is charged with a crime in Florida. He's convicted. Murphy appeals. The case gets to the Supreme Court. And Murphy's argument is that pretrial publicity that included his connection with the Star of India sapphire theft from a museum in New York and his indictment on federal murder charges meant that he couldn't get a fair trial. Justice Thurgood Marshall writes for the court that jurors can go into the courtroom knowing something about the defendant and even having an opinion as to the defendant's guilt. But Marshall wrote, it's sufficient if the juror can lay aside his impression or opinion and render a verdict based upon evidence presented in the court. But on the other hand, we have Patton versus Yount. John Yount is convicted based on his confession to the rape and murder of one of his math students. His conviction is overturned by the Pennsylvania Supreme Court because his confession was improperly obtained. He was not given his Miranda warning. When he was retried, the stories about his confession and early conviction had been widely seen. He was convicted. His appeal ultimately made it to the Supreme Court. The Supreme Court upheld his conviction, holding that even though the community was aware of Yount's prior case, even though they had been aware of his confession to the rape and murder of the young woman, it was not shown that the jury was not able to set aside its opinion about the case and judge it solely on the evidence presented at trial. And Justice Powell wrote that the voir dire process demonstrated the impartiality of the jury. He focused on the examination of a juror named Wren. In questioning, Wren said that while he had an opinion as to Yount's guilt, he could still judge the case fairly. And Powell cited a quote from the transcript of the voir dire questioning, in which Wren said, I think I could enter it, the jury box, with a very open mind. The dissent also focused on Mr. Wren's voir dire examination. And you see here on this slide what Mr. Wren said in response to questioning from the defense lawyer. Would you require evidence before you would change your opinion as to Mr. Yount's guilt? And Mr. Wren said, definitely. If the facts showed something different, then I'd change my mind. And the defense lawyer said, okay, until you're shown those facts, you still think Yount is guilty? And Mr. Wren said, well, I have nothing else to go on. And the defense lawyer nails it down, saying, you would not change your mind until you were presented facts. And Mr. Yount said, yes, but I would enter it with an open mind. Who knows why this is not constitutional? Okay, some of you do. And some of you realize it's not constitutional because of the presumption of innocence. Everybody comes into court under a presumption of innocence. The prosecutor's job is to overcome that presumption of innocence, and if the prosecutor does not present evidence, compelling evidence of the guilt of a defendant, the jury must acquit. But this portion of the transcript shows that Mr. Wren is placing the burden of proof on the defendant. The defense lawyer has to present evidence to show Mr. Wren that Mr. Yount is not guilty. That's not kosher. But it was the dissent. And the majority of the Supreme Court said, no, we think Justice Powell is correct. You have to understand that we have tremendous power to influence jurors and judges. Sometimes the judges can overcome that, but no matter what, judges have the responsibility for seeing to it that defendants get a fair trial. So that creates a clash between the First and Sixth Amendments. Okay, we've dealt with publicity pre-trial. Now let's talk about publicity during the trial. The Bruno Hauptmann case. You'll recall from history that Bruno Hauptmann was an auto mechanic who was the sole defendant in the kidnapping of the Lindbergh baby. Remember, Lindbergh, the Lone Eagle, made the solo flight from the United States to Europe. He was given worldwide acclaim. He was married. One night, when the Lindberghs were out, somebody took their infant child from the house. The child was discovered dead in a ditch some days later. Mr. Hauptmann was informed on, and some of the ransom was found in his lodgings. Mr. Hauptmann said he was innocent, that he wasn't aware of the money. He was convicted and put to death. Read the section on the Hauptmann case. Read just what we did. how we walked around the courtroom during trial. We took pictures. We dictated stories within the hearing of the jury in which we talked about Hauptmann as being obviously guilty, in which we described him as a thing with dead eyes. Mr. Hauptmann went to his death protesting his innocence. The problems with that case led the Bar Association to adopt Canon 35, which at the time made taking pictures in the courtroom prohibited. Some years later, in Estes versus Texas, the Supreme Court held that the presence of a TV news camera in the courtroom meant that Mr. Estes does not get a fair trial and overturned his conviction. Cameras are back in some courtrooms. Back in the Estes case, cameras were dinosaurs. They were loud. They were big. They built a special booth in the back of the courtroom for the sole television camera. Even so, the Supreme Court in the Estes case said the presence of the camera in the courtroom was prejudicial, and so it denied Mr. Estes a fair trial. But now cameras are tiny. They're silent. The federal system has had some experimentation with cameras in the courtroom. It's not going to happen in the Supreme Court. Chief Justice Berger and also Justice David Souter both have said there would be cameras in the courtroom over my dead body. Chandler versus Florida is a key case that established the right of states to permit cameras to be in a criminal courtroom. In the Chandler case, you had two police officers from Miami Beach. They were supplementing their income by committing burglaries. They were using their police radios, and that's how they got caught. They had cased one home. One was at the front, one was at the back. They were talking over the police radios about no one being home, and because it was a police radio going out over the police frequency, somebody heard them. They sent officers to the home and caught them in the act of burglaring. They were prosecuted. The trial court allowed cameras into the courtroom for the trial. The officers were convicted and they appealed. They appealed. The Florida Supreme Court refused to hear the case. The United States Supreme Court held that the conviction was proper and refused to overturn it. They voted 8-0. And they did it not necessarily on the basis of cameras being good. Chief Justice Berger wrote the opinion for the court, and he said principles of federalism allowed states to establish their own rules regarding cameras in the court. Remember, the principle of federalism is those things that are not reserved to the federal government are within the purview of the individual states. So all 50 states now allow cameras with different restrictions, different qualifications. Check with your editors or your bosses, wherever you wind up, to find out how to get cameras into the courtroom. And then we have our really terrible case, the case when everything went wrong, when we were just a bunch of patootie heads, the case of Sam Shepard. Dr. Sam Shepard woke up in the middle of the night. He had been asleep in a different room from his bedroom. Something woke him up. He said he started up the stairs to go to his bedroom where his wife was sleeping, and a mysterious man appeared and pushed him down and hit him. And he lost consciousness for a second. Then he regained consciousness and followed the mysterious man out of the house, where he ultimately lost him. He went back to the home to find his wife had been murdered in their bedroom. Everybody was bad. Everybody was rotten. The prosecutor held regular press conferences in which he talked about evidence. One of the prosecution press conferences said it appeared that Mrs. Shepard had been killed with a medical instrument. They determined that from the outline of blood on the sheets, but at trial, the prosecutor never produced any medical instrument. The prosecutor talked about Dr. Shepard's behavior. He had been uncooperative. The local media and national media went after Sam Shepard. A columnist talked about Shepard's silence, his obviously guilty behavior. The judge allowed this to go on. The judge allowed the members of the jury to be photographed. So here you are in a case in which the local media are crying for a conviction for Sam Shepard, and the 12 people on the jury, the judge allows their photograph to be published in the newspaper, their names to be published in the newspaper. And that means that people in the public can say, oh, hi, you're on the jury trying Sam Shepard. You should convict him. And it meant that the jury members were under some public pressure. Dr. Shepard was convicted, sentenced, sent to prison. Years later, the Supreme Court heard the case, and they reversed the conviction, and they had very strong words about the prosecutor and the judge and the media. And he became, in essence, the visible figurehead for the clash between the First and Sixth Amendments. Well, after this happened, the American Bar Association came up with guidelines to protect the defendant's Sixth Amendment rights. And through case law, in addition to the bar rules, we now have ways that judges are supposed to behave to protect the rights of the defendant while not diminishing First Amendment rights. So 5 ways judges are supposed to protect the Sixth Amendment rights of defendants. The first is a change of venue. You move the trial to a place where jurors haven't been exposed to all the pretrial publicity, where they haven't been influenced by that. I covered a case, a capital murder case in Texas, where the case had been transferred from Lubbock up in North Texas out to El Paso in far West Texas because of publicity surrounding the killings. Second method is continuance. Continuance is a postponement, and here the judge will delay the trial to let the publicity die down. The defendant here has to give up a right to a speedy trial, but in order to get a less prejudiced jury, defendants will do that. Voir dire, which is how we say it in Texas, technically you should say voir dire, to speak the truth. This is an examination of prospective jurors. And here's how that works. If you're called for jury duty, you show up at the courthouse, they may send you to a courtroom, they'll have you fill out a questionnaire. Sometimes it's a general purpose questionnaire. Sometimes the questionnaire is written to ask questions relating to the case. Then the attorneys and the judge get to see the questionnaires, and they bring jurors into the courtroom individually. In other words, you're not in front of the other prospective jurors. You're seated, and both sides, the prosecution and defense, get to ask you questions. The judge gets to ask you questions. At the end of the time, both the prosecution and defense can strike you, that is to say, remove you from the prospective jury panel for cause. For example, if you are related to the victim is your brother, then the defense could strike you from the jury pool for cause because of your relationship and the likely effect it will have upon your verdict. If you are not eliminated for cause, you go into the pool. After enough prospective jurors have been looked at, then both sides have a second way of striking jurors. This is a peremptory challenge, a challenge not based upon cause. It's just that I'm the defense lawyer and I don't like the way you looked at the defendant, or I'm the prosecutor and I think you look too liberal to sit on this jury. And that's limited. Sometimes it'll be 6, sometimes 3. And then the jury is made up of the people who are left over. So let's say 40 people walked into the room for voir dire. and the prosecutor struck for cause 5 jury members. The defense struck for cause 5 jury members. Now you're down to 30. The prosecutor can, in this case, strike 6 just because they don't like them. The defense can strike 6. So they exercise these peremptory challenges. So you have 12 out of 30, which leaves you 18. So the first 12 of those 18 are now the jury. And if there are alternates, then they come from, 13, 14, and 15. So the jury selection really is not a process of selection, it's a process of elimination. And the third way that judges are supposed to protect the Sixth Amendment rights of defendants is to use examination of prospective jurors to weed out those people who cannot fairly judge the case. The fourth method is sequestration. You lock up the jury so members cannot see potentially prejudiced stories or be influenced by members of the public. And this is where the jury's been selected. The judge says you're going to be sequestered. Go home, pack some clothes. So all the members of the jury wind up in a local motel or hotel. Double occupancy. And it's going to be the low bidder, so it's not going to be a 4-star hotel. You don't have access to television. You wouldn't have access to the internet. If you do want to watch television, you have to watch television in a common area, and a bailiff assigned to the jury has control of the remote. And if anything comes up in a TV show or a newscast or a breaking story, the bailiff will turn off the TV. You may be allowed to read newspapers and magazines, but the bailiff will go through the newspaper magazine and clip out stories that could affect your judgment. When you get up in the morning, you go as a jury to get breakfast. You go to court then, you hear testimony at lunch. You go back usually to the same place with the jury for lunch. Go back to the court. After the day's proceedings, as a group, the jury goes to someplace for dinner, and then it's back to the motel. This sequestration is a way to ensure that nobody is being influenced by anything outside the court. And then contempt of court. That's the fifth method. Using the contempt power of the judge, trial participants can be controlled. You should know that the prosecutors and defense lawyers are officers of the court, and the judge can order them to shut up. The judge can also issue gag orders to trial participants. Remember, though, that gag orders must be limited to trial participants and not applied to the press. In Nebraska Press Association, the judge issued a gag order on the media covering 5 topics in the case. The Supreme Court overturned the prior restraint because it was a prior restraint. Back to Gannett. So the judge in Gannett versus De Pasquale closed the pretrial hearing to protect the Sixth Amendment rights of the defendants. It was upheld by the Supreme Court. But the Supreme Court since then has backed away from that extreme position in Press Enterprise 1, Waller versus Georgia, and Press Enterprise 2. You'll recall that those 3 cases, judges closed pretrial hearings. And in those 3 cases, the Supreme Court reversed that and said the pretrials had to be open. So now, if a judge wants to close a pretrial, the judge has to follow the rules. We've seen this before, but now this is expanded. The judge must, before closing a pretrial, conclude in a hearing that without closure there would be irreparable damages to the defendant's fair trial rights, conclude that there were no alternative means to deal with the threat, and conclude the closure would be effective. So, the footnote, alternative means the judge must consider the 5 things: change of venue, continuance, voir dire, sequestration, and contempt power. And if the judge has not done that, and has not concluded that even with those things, the defendant's Sixth Amendment rights would be lost, then the pretrial must be open. And to close a trial, the judge has to, in a hearing, make detailed findings, conclude a substantial probability of prejudice, and must have considered alternatives, and choose the least restrictive means to protect the interests of participants. So, the alternatives again, the judge must have considered change of venue, continuance, voir dire, sequestration, and contempt of court before closing the trial. And that, in a big nutshell, is covering legal problems in reporting the courts. So, be ready for the lecture for Chapter 10. I will send you an email about the process for doing the final, and you should get that either late this afternoon or sometime tomorrow morning. Talk to you soon.